Paul. I found this interesting. You and your protection. Needless to say, if at any time during any of the procedural steps outlined above as typical in a criminal trial, your lawyer should come upon evidence establishing that someone put the paper bag in the borrowed car that day, whether to frame you or simply to get rid of it for fear of his own prosecution. The unknown witness who had so on and so forth, so on and so forth. He would present that evidence to the proper authority, page 183. Now, let's say I had informed my public defender when I was arrested in 2004, or 2015, January 4th, 2015. And I had been emailing the authorities that my right to due process had been violated. And he in his response said, well, he had a copy of this, and he says, well, this is silent, but of course it's not silent when I wasn't there before there was a court hearing. It's not signed. This signature is not the same as this signature. This is not filled out. This is a lie. Okay, the restraint had actual notice. No, I didn't have actual notice. Now, I had sent some emails along the line that having evidence that 100% this is not signed would remove me from the scene of the crime. It was obvious I was being framed for a crime in 2015, and I was being framed for a crime in 2012. You called the police 20 days later. You filled out all the dissolution of marriage paperwork on the 24th. You served me on the 27th when you arrested me, and then you motioned the court when I got out of jail 1 day later to renew the protection order. Now, being found not guilty, looking at all the forgeries and all of those that were not Heidi Budnick, it would have been the responsibility of my attorney, as soon as they had evidence that another crime was happening, that a fraud, deceit, and misrepresentation was happening, to inform those that are sheriffs and police officers of the crime that my wife was committing. Now, when I provide 50 pages in my response to the petition, approximately 50 pages of documentation, 5 pages of typed written response, and there is no documentation from my wife, and there's nothing but handwritten notes about what she wants. It's somewhat obvious that the court never required anything of any substance to justify the decisions of the dissolution of marriage. Now, when I had responded on the 24th, see this motion for default on the 27th, order of default. When I read order of default, my impression was that they did give her the default dissolution of marriage. Now, I had looked online, I think it was a Monday, I can look exactly what the date was, or the day of the week, but when I saw order of default, I interpreted it as that Brent Basden decided that he was going to grant a default dissolution of marriage. Well, I ran down to the courthouse as soon as I was able to get here, and I looked at the documentation, and then I looked, it said Heidi Hodges. Heidi Hodges. Now, you would have thought that any time you motion the court that you have to use your actual last name before you're divorced. Now, I know this court has been reluctant to charge women with the crimes of fraud or perjury or misrepresentation or deceit or abduction or kidnapping or conspiring to defraud me of my inheritance or my actual wealth, but I'm pretty sure that every sheriff in Culpeper